Hi, I'm Dennis Cuevas, Director of the CLE program at the DC Bar. We hope you're enjoying this virtual conference marking the 100th anniversary of the 19th Amendment. This session, Voting Rights of Incarcerated and Returning Citizens in DC, Current Procedures and the Path Ahead, is eligible for CLE credit in all states that have continuing legal education requirements. An alphanumeric code will be read out loud and displayed sometime during the presentation. Please take the time to write down the code. Within the next 24 hours, those of you who have registered and paid for CLE credit will receive an email with a link where you will then identify the correct codes to receive credit. As we enter our busy season with many state CLE deadlines fast approaching, please allow up to 30 days to process your certificate. Also, in that same email, there will be an electronic evaluation form. Please take the time to complete the evaluation. We need a number of them back for accreditation purposes, but more importantly, we review them carefully as we always look for ways to improve our classes. If you have any questions about obtaining CLE credit, please send an email to cle@dcbar.org and we'll be happy to assist you. If you're watching this pre-recorded program during the live broadcast, please feel free to pose any questions you have in the chat room, since our presenters will be available at that time to answer any questions that you have. Now, without further delay, let me turn it over to our distinguished speakers. Enjoy the program.
Thanks, Dennis, for those administrative announcements. Hello, I'm Rainey Brandt, and I'm your moderator for this session. I'm an associate judge at the Superior Court of the District of Columbia, currently presiding in the Criminal Division, handling felony cases. Additionally, I'm an adjunct professor at the American University in their School of Public Affairs, Department of Justice, Law, and Criminology, where today's topic, the voting rights of the incarcerated, is often debated. As your moderator, I'm hoping for a very lively and informative discussion. Today's panelists are Mark Maurer and Michelle Wilson. And I apologize in advance because you don't like to be read to, but they bring such great credentials to this discussion that I don't want to get anything wrong. Mark Maurer is one of the country's leading experts on sentencing policy, race, and the criminal justice system. He has directed programs on criminal justice policy reform for 40 years and is the author of some of the most widely cited reports and publications in the field. The Atlantic magazine has described him as a scholar who has, and I quote, reframed how Americans view crime, race, and poverty in the public sphere, end quote. His report on racial disparity in the criminal justice system led the New York Times to editorialize that the report, and I quote again, should set off alarm bells from the White House to city halls and help reverse the notion that we can incarcerate our way out of fundamental social problems, end quote. Michelle Wilson joined the District of Columbia Department of Corrections as an attorney advisor in just January 2020. Prior to joining the Department of Corrections, Ms. Wilson spent 4 years as an assistant attorney general for the Maryland office of the Attorney General. There she represented both the Department of Public Safety and Correctional Services and the Department of Labor. Prior to joining the Maryland office of the Attorney General, Ms. Wilson was a prosecutor in the state's attorney's office for Baltimore City for 10 years. 4 of those years she spent prosecuting homicides. Additionally, she's an adjunct faculty member at the University of Baltimore School of Law, where she teaches first-year students about legal advocacy and writing. She's also an adjunct professor at Strayer University, where again, she gives her time educating undergraduates and graduate students in the areas of business law and criminal law. Mark and Michelle, thank you both for being here.
Thanks for having us.
Let me put some background to our topic for today. July 7th, 2020 was a most historic day here in the District of Columbia. The City Council unanimously passed a justice reform bill that included extending voting rights to DC residents who are currently incarcerated on felony offenses. A more permanent vote on that legislation is expected sometime later this fall. In a few moments, we'll discuss more about that new legislation. But first, I want to turn to Mark. And Mark, could you give us a national overview of what's going on with respect to voting rights of the incarcerated?
Sure, thank you. Well, for ever since the time of the founding of this nation, there have been laws in place that disenfranchise people with felony convictions for some period of time. This may include time during which they're incarcerated in a prison, and maybe while they're under probation or parole supervision. And in some states, it can also extend to a post-sentence period. Even after someone has completed all terms of his or her sentence, they still may be disenfranchised, sometimes for the rest of their lives. The district joins very select company right now. There are only 2 states, Maine and Vermont, that enable everyone to vote, even with a felony conviction, even in prison. Maine and Vermont have done this for many years. In addition, the Commonwealth of Puerto Rico has done this for many years as well. And so the district is now joining this select company, essentially in extending the franchise to all, and essentially making a distinction between punishment for a crime from your rights as a citizen of the country.
Mark, let me ask you a question. How many people are we talking about? What's the volume, if you could give us a ballpark figure?
Well, nationally, research we've done at the Sensing Project 2016 showed that 6 million people were unable to vote during the election season that year because of these policies in 48 states and the varying categories of disenfranchisement that they suffered from. So that's a very dramatic number. We're talking about real impacts on real elections, in addition to the questions of democracy. Just as is true the criminal justice system, broadly speaking, we see extreme racial disparities in how felony disenfranchisement plays out nationally. 1 of every 13 African Americans is ineligible to vote because of a current or previous felony conviction. So the numbers are substantial. To my mind, even if it's one person who is disenfranchised, we should be having a debate about whether this is an appropriate kind of policy in a democracy. But given the rise of mass incarceration, we're talking about a very substantial impact, and of course varying considerably by state as well.
And I'm glad you mentioned varying by state, because does this mean that in some jurisdictions across the country, incarcerated people who are no longer incarcerated, is a distinction drawn between whether or not how long it takes to reinstate their voting rights versus it being automatically? Does it extend to people who are on probation and parole?
Yeah, of the 48 states that disenfranchise people incarcerated for a felony, 30 of them also disenfranchise individuals on probation and or parole. So if you come out of prison and you have a parole period of, say, 3 to 4 years, if and when you complete that successfully, then you automatically regain your voting rights, but not during the period of supervision. In addition, as I mentioned earlier, in 11 states, some or all people with felony convictions, even after the period of supervision is legally over, you still lose the right to vote, and it can be for a period of years, or it can be for a lifetime. The only way out of this status is if you get a pardon from the governor of the state or from the president, in case of federal penalties. And in most states, that's a very unusual outcome for people.
Many of you are probably aware that the District of Columbia doesn't have its own prison system. Our sentence felons are moved into the Federal Bureau of Prisons to serve out their felony terms. However, the DC jail still hosts a variety of different individuals, among them pretrial detainees, both misdemeanants and felons, sentenced misdemeanants, and of course sentenced felons who are awaiting transfer into the Federal Bureau of Prisons to serve their sentences. So, Michelle, what are the voting opportunities like for that grand mixture of people at the DC Department of Corrections?
So we're proud to say at the DC Department of Corrections that we have a robust opportunity for individuals in our facility to register to vote. There are, certain limitations which are mandated, that you must be a U.S. citizen in order to vote. You cannot be claiming the right to vote in another state. And you must be at least 18 years of age, and no judge has ruled you incapable of being able to vote. The last main requirement is that you must be a resident of the District of Columbia for at least 30 days. And so the deadline that we've been given by the Board of Elections is October the 19th. So anyone who is in our facility as of September 18th, September 19th, given the 30-day count back, is eligible to vote in the November election if they meet that criteria. And so we are actively engaging and encouraging. We've established a voting coordinator, and we are giving out materials to our residents to actively encourage them to register to vote. And by registering, they don't even have to, in most states, you have to request an absentee ballot. If someone in our facility registers to vote, that is considered and lists the Department of Corrections address as their address. That is being considered their request for an absentee ballot. And so they're being mailed an absentee ballot. So they don't even have to do the additional step of requesting an absentee ballot. It's automatically being sent to them. And the first mailing actually went out this past Monday, and then another mailing of ballots will go out, I believe it's the 13th. And we're working with the Board of Elections to establish how, because our last day of registration is the October 19th, to get those last people their ballots as well.
So, Michelle, you mentioned something interesting, that DC Department of Corrections has a voting coordinator. Can you talk a little bit more about that?
Yes, so we have established, so every 2 years we establish, because elections happen in the district every 2 years. So we have a person or people who work as our voting coordinator. This year we have one person who's working for both our facilities, the CDF, which is the Correctional Treatment Center facility, and CDF, Central Detention Facility. Excuse me, I switched those around for a second. But so we have or known as the jail. CDF is known as our jail. We have a coordinator who's overseeing both facilities this year, and her responsibilities include distributing registration forms. So in September, when we kind of kicked off, she initially distributed 1,300 voter registration forms out to all of our residents within the facility. And then what she does is she also coordinates and collects those registration forms, sends them into the Board of Elections. She will also be the person, the jail was supposed to be be able to cast your ballot on election day. But unfortunately, because of COVID, we can't do that. And we're not going to be able to be a vote casting location, but we will be able to collect those votes. And she is collecting all the ballots and actually physically turning them in at the Board of Elections. So every vote will count. And she will do that on election day, which is the last day, and physically take them to the Board of Elections so those votes count.
So I want to clarify something, if I can, with your help. You mentioned that as long as a person in DOC's custody requested a ballot and listed the DC jail as their address, they would be allowed to vote. Did I characterize that correctly?
That is correct.
Okay, so say I am a resident of Virginia, but I come to DC and unfortunately get arrested and end up at the DC jail. Can I vote?
So a couple of things. Depends on when you arrived. Number one, so if you arrived at the DC jail from Virginia today, you would not be able to register to vote because you wouldn't meet the 30-day requirement. Okay, so that would be the number one. So, but if you arrive, say you arrive September 1st, and you are saying that the only place that you are going to vote is in the District of Columbia, you want that to be listed as your permanent address at this point in time, and your primary address would probably be a better word. Your primary address is the District of Columbia, and so you want to be considered a District of Columbia resident. You will be considered a District of Columbia resident if you arrived on September 1st. I'm just using that as an example date, and you will still be in the facility at the time to vote, and when it's time to vote. And so you will receive an absentee ballot. And like I said, those ballots have, if you register, say September 1st, you should receive your ballot this week. So, or you should receive your ballot, I should say, the first week in October. And then receiving your ballot the first week of October, you will have the opportunity to vote in the election. And that will be you, but you've established that DC is your residency. Yes.
So does the new legislation affect the District of Columbia Department of Corrections at all? In other words, what you are currently doing, does it change under the new legislation?
No, not really, because we've made the restore the vote for us. We're allowed to register. I guess the only change would be that we don't look at whether or not you've been convicted of a felony or any of those things, because anyone who is in our facility who wants to list the District of Columbia as their primary residence and the facility as their address and meets the requirements that I've outlined earlier in terms of citizenship and age and all of those things and residency, they can vote. So we don't look at, we're not tracking whether or not you're a convicted felon, whether or not, any of those things. We're registering people to vote.
Okay, so Mark, do you A, agree with that, and B, could you unpack the new legislation a little bit for us?
Yeah, well, I think that the Department of Corrections is to be commended for its work in making sure that the legislation is implemented very properly. And of course, the jail officials, for some years have made provisions for people who are essentially pre-trial there to be able to vote. These are people who were legally eligible to vote for many years, and they've done this. And many jurisdictions in the country, have never even considered doing this for their pretrial or misdemeanor population. So that's very important. So we've got essentially now with this expansion, I'm confident that in the DC jail, people there on a felony conviction, I think we have a good opportunity to reach that population and aid anyone who wants to register and vote in doing so. The more challenging element, of course, is the several thousand people in federal prisons around the country who are DC residents, and how to make that a reality in terms of making the registration process as accessible for that group of people too.
So it's my understanding from reading the new legislation that really the DC agency that has a requirement or an obligation is the Board of Elections. And in fact, the legislation clearly states that starting in 2021, the Board of Elections will be required to work with the Bureau of Prisons to get the addresses so that absentee ballots can be sent all over the federal system for our DC incarcerated felons. That's a lot to unpack there. Are you hearing anything, I guess, through the grapevine, so to speak, about what BOP's attitude is right now in terms of following the new legislation?
Well, what we had heard initially was that when the Board of Elections was reaching out to BOP, essentially asking for the information regarding DC residents who were incarcerated in one of the federal facilities, the response they initially received was, we are not able to tell you that because of privacy concerns. We can tell you how many residents we have in our facilities, but not who those individuals are or identifying information. I'm not an attorney. I can't comment on whether that's an appropriate response or whether there are ways that they could go about making that information available, but that was the initial response that was given to them. And of course, doing that would add several extra hurdles to making the process accessible. It would essentially mean sending, say, 50 registration forms to a given federal prison and making sure that the right person in the prison got to all 50 people who are incarcerated there. And that just seems like it's a big additional step that is not necessarily a reasonable way to go about this.
Michelle, is the DC Department of Corrections I guess, prepared to lend a helping hand in terms of addresses or trying to identify who the sentenced felons are for the Board of Elections, considering that they're all going to pass through the DC Department of Corrections before going into the federal system?
I mean, we will certainly help as much as we can. I will let you know that for us, we only know where someone is when they're with us. And so once they leave and they are taken to a Federal Bureau of Prisons facility, we, as far as we know, they leave. Like, we have some limited information, but we don't necessarily track someone's movement within the Bureau of Prisons. And so it's any way we can assist, we will certainly do so. But our information is not, we don't have a lot of information. And we don't, as people move through the Bureau of Prisons, we also don't necessarily have information about that, you know, and so that it limits our ability to assist in a lot of that.
So essentially, if I'm a sentenced felon right now, and I'm in the DC Department of Corrections custody at the jail or CTF, I can vote for the November election, correct?
Absolutely, yes.
Okay.
But as long as you meet the requirements, yes.
Of course, let's not forget those requirements. But right now, if I'm a sentenced felon and I'm in any federal facility, the chances of me being able to actually cast that ballot, wouldn't you say, Mark, are slim to none in 2020 for the 2020 election?
Right. I mean, those DC residents who either themselves or through family members have learned about this new legislation and have received information about how to request an absentee ballot and the like, you know, those people hopefully would be able to vote. But, you know, clearly it shouldn't depend on the initiative and the information that some individuals may have access to, as opposed to making the process transparent and open to all. You know, that's what we do routinely through the motor voter law, encouraging people to register. We have election officials going to meet with high school seniors who will soon be turning 18. You know, we don't make that process difficult to access, or at least we should not be doing that. They have a legal right as much as anyone else in the country to vote, and we should make them well informed and have access to making that happen.
So in July 8th Washington Post article, the Bureau of Prisons made the following comment, that they are going to adjust their policies so that DC residents in their custody can receive the absentee ballots, but in terms of making sure those ballots get returned to the DC election board, some sort of prepaid return envelope is going to have to be included. I got my ballot, my absentee ballot yesterday in the mail, and there was no prepaid envelope inside there. So any comment from either of you about that?
Well, I think it's, one more hurdle. Judge, you have a reasonable salary, and I'm sure you can afford the postage to put on your ballot. It's a very different story if we're talking about individuals incarcerated who, earn very little money while they're there and have to spend it on commissary items and the like. And the stamp doesn't seem like much to most of us, but it takes on much broader meaning for someone who's behind bars.
Any comment, Michelle?
I would agree and concur with Mark in saying that, and plus, we'll talk more, I know, about encouraging our efforts to encourage people to vote, but there is still a level of apathy, or like, will my vote really count? So any hurdles in terms of having to use your own money in buying stamps and doing those things, that is a hurdle, and it is an obstacle for someone who is already fearful or already thinking that their vote might not, he or she thinking their vote might not count, or nobody, can I really vote? And then having to use your own money, do they want to do that? Would I want to use my own money and thinking my vote, are they even going to count my vote? Or is there any effort to this? And then, people watch the news, and can you trust that the post office is going to deliver it? There's also that concern. So any obstacle that's in the way is something, you don't want those things, and we don't want those things, certainly at the DC jail. And that's why we're trying to do as much as we can so that those obstacles, are not there.
Going to be drawn in the sand. But for now, this discussion needs to, and aptly should, turn to the challenges that are commonly associated with making sure any of our incarcerated residents can vote, and what those challenges are. And hopefully, as we unpack the discussion, we can talk a little bit about ways that the DC bar, can help. So I'm going to turn to Michelle first to give us the local lay of the land, and what challenges or resistance has the DC Department of Corrections encountered?
I don't think within the department or the agency itself we've encountered challenges. I think that trying to get people to vote, I talked to our voting coordinator before this presentation, and 2 years ago she was just in charge at CTF, and she said she registered 35 people to vote in the election 2 years ago. And so our goal, and the director's goal, was 100%. He wants 100% participation, and that's over 1,000 people registering and casting, or potentially, let's say 1,000 people casting a ballot and being able to vote. And realistically, we those of us on the front lines don't think we'll reach that number. But just 2 years later, so between CTF and CDF 2 years ago, we probably registered under 100 people, maybe right around 100 people total for both facilities. This year alone, we've registered, as of September 30th, 333 people. So that's a big number. That's a big jump for us. It's not 100%. We'll have to look at what 100% looks like and what that total number is, but that is a significant jump. And I think that speaks to our efforts. But what we're facing is that there is a level of for the residents of our facility is maybe a level of apathy, maybe a level of, will my vote count? Many of the individuals in our facility have never voted before. And so thinking about, does my vote matter? Does it count? And then for some of them, it's who do I vote for? Like, what the candidates seem just as bad, or the options seem just as bad. So why should I care? Why should I get involved? And so our goal is not to, as DOC employees, is not to tell people who to vote for, or is not to tell them what political party to vote for, or to have a voice in that part of the process, but to remind people that who the parties are, and that this is more than just a presidential election. There are, so often we think in terms of a large scale, but there are local elections to think about and other things to think about. And so those have more of a immediate effect on people, like the ability to restore the vote came from the local council making that vote, and not on the national level. So people often think big when we need to think that our vote on a local level sometimes counts more in our day-to-day activities. So encouraging people to vote. We give out sample ballots so they see who's on the ballot. They see what they'll be voting for. We've tried to do that. We've explained that there are what political parties are out there so that they're aware of those things. The League of Women Voters has given us some information about voting. We've given those to the residents. And this might sound minor, but we've included word search puzzles as part of our packets that we're giving out, because we found that our residents like to be engaged. They like to have things to do. So just giving them puzzles and things to fill out and activities makes them feel like a part of a process. The other part is that we've gotten stickers from the Board of Elections that say I've registered to vote. So we're giving those out to everyone who has registered, so that, source of pride, like I've registered to vote, and that's hopefully encouraging other people to vote as well. We plan to give out the stickers that say I voted. So once we start collecting the ballots back, we will give out stickers that say that I voted, so that people will know and will have that as also a source of pride to say that they voted. So we're trying to do those things, because we don't have an actual polling place. We have to physically collect the votes and take them in, and we're doing that. We also relying on, just as outside forces, we rely on the mail, because our residents have to get their ballots in the mail. They're coming from a clearinghouse that's sending the ballots to us. So the first round is due the week of October 5th, and then another mailing will go out after that. So we are also, and they are also relying on the mail to receive their ballots. And so, that's a big deal as well. So it'll come in the mail. It'll be part of the mail that they receive. They'll get their ballot and they'll be able to vote just like every other citizen who is choosing in this election because of COVID or for whatever reasons to do absentee ballots. So those are some of the things that we're facing.
I have to say, Michelle, your enthusiasm about this subject matter is so refreshing that you should be the person in there encouraging all of our incarcerated residents to vote, because you certainly know how to rally the troops. I applaud you, and I applaud what the Department of Corrections is doing. I do have a couple of questions for you, but I want to give Mark an opportunity to comment on what he's just heard.
Yeah, well, first, I will second the nomination of Michelle to be the voting coordinator, certainly, and we could use that in many places, too. I think it really is critical that the institutions take this on in a serious way. In the two states I mentioned, Maine and Vermont, the officials within the correction system, make information available to people who want to vote. Excuse me, there they vote by absentee ballot from their home address. It's hard to get numbers on how many take advantage of it, but people are voting routinely. It hasn't been disruptive by any means or things like that. Across the country, not looking at people with felony convictions, but the normal jail population, again, mostly pretrial, mostly misdemeanors. Some other large jurisdictions have also been implementing this process in recent years. So we've seen Los Angeles, Chicago, Philadelphia. There are ongoing campaigns and with officials within the jail administration to try to make this as viable as possible. So it's encouraging to see these developments, but they remain the anomaly in most cases.
And I know, Michelle, that the Department of Corrections has actually developed videos. Do you play those videos in support of the vote for the residents?
So absolutely. So what we've done is we've created flyers, which we and let me say that DOC has a wonderful team. Our voting coordinator, she's the one who I feel like has educated me. Miss Towns is phenomenal, and so she has sat with me. We've talked about this. I've been in the facility, but numerous times. But quite honestly, the best thing that we've done is we've created flyers throughout our that get posted throughout the facility, which are encouraging people to vote. We've created a video which we will put on the tablets, our tablets, which many residents have, and we are in the process of rolling out tablets to over 1,000 of our residents now, which is similar to like an iPad, but not quite. But we're in the process of rolling those out. So we have probably about 500 residents who, at this point, maybe a little bit more, who have tablets. The videos are actually residents who have registered to vote. They've made these short videos just basically encouraging everyone to register to vote. So we're rolling those out and putting those on tablets. And so anything that we can do as a community, as a facility, as an agency to get our residents encouraged and enthusiastic about voting, we are trying to do. And so we have the flyers, we have the posters, and we've given out, I think, our first round, we did 1,300 registrations. Then 2 weeks later, we gave out another 1,300 registrations. Ms. Towns realized that giving them to the same residents, they were registering again. So now we are tracking who has already registered. So we give out packets to those who have not. So we're continually encouraging, revamping, thinking of new ways, new ideas to really facilitate and encourage people to register, to use this opportunity, and ultimately to vote as much as possible.
So let me ask this, going back to the challenges that sometimes occur. So first, how do you handle special handling prisoners, for lack of a better way to classify them, in their ability to vote? In prisoners who may be on segregation, or prisoners who may find themselves in the infirmary. How is DOC handling their ability to vote?
We're treating them, so even our residents who are in the medical unit or who are in restrictive housing have access to receive the same information and receive the same materials, and they appreciate, I think, to a certain extent, especially when, like I said, we're trying to include word puzzles and different things, word searches and things like that in it. They have those materials as well. We're not limiting, because they might have limited access, and quite frankly, the jail itself right now, because of COVID, is the movement within the facility is limited for all residents. So everyone is on limited movement, but the employees who are providing the materials, they still provide and are still giving those materials out to those who are in medical and those who are on restrictive housing as well.
Okay. And I guess this next question goes to both of you, Michelle at the DC level, Mark at a more national level, or DC level, whichever you want to comment with respect. But as I mentioned earlier, I got my absentee ballot yesterday in the mid-up, and one of the first things I recognized was, oh my goodness, how small the print happened to be. And then I started to think about all of our incarcerated individuals who may have special needs, like vision issues or reading issues or non-English speaking individuals. Who helps them cast their ballots? Whichever one of you wants to jump in.
That's an excellent question, and clearly it pertains beyond just voting inside institutions, but with voting in particular, it's quite critical. I honestly don't know how most other institutions are handling this. One would hope that the ones that are enthusiastic about making voting widespread within jails and prisons would make provisions along these lines, but I don't know to what extent that takes place right now.
Michelle, how does BOE, the Board of Elections, do they have monitors that come into the jail? I know you said the jail wasn't being used as a polling place this year for obvious reasons, but are they the ones that get called in for help?
That's a good question. So far, the Board of Elections has not come in to assist with voting. Our ballots just arrived. I think that if a resident required or needed help or requested help, that would be the first thing. They would have to request assistance with voting. The person, our voting coordinator, has been trained by the Board of Elections. She would probably be the person to assist if anyone required assistance with their ballot in terms of and requested help with their ballot. She would be able to assist them because she has received the training from the Board of Elections.
And again, to all of our DC bar members, this subject, this particular topic might be a way for you to get involved in providing assistance with helping our incarcerated individuals, our DC citizens, maintain and voice their right to vote, exercise their right to vote, rather. So, Mark, here we are.
Can I say one
sure,
thing?
Go ahead, Michelle.
I just want to, because even as we encourage the bar members, I think first and foremost, they should all encourage, if they have any clients at the jail, encourage them to register to vote, and they can ask their client if they need assistance and reach out to us to let us know that, because sometimes people don't want to tell us directly. But I would tell attorneys right now, we are limited in terms of attorneys who are not representing someone coming into the facility. So I don't want to encourage people to think they're going to come in the facility and be able to do what we normally, to be election watchers or poll watchers and to come into the facility, because we don't have a polling place because of COVID. And if you don't have a client, you can't come into the facility. But attorneys, if you do have a client in the facility and you choose to come in, you can make an appointment and come in. We have video for attorneys who want to speak to their client via video. Those options are available, and of course the phone. But let us know. People email me all the time with questions or comments, and if this is a concern and their client wants to vote and they have a concern, please let us know, and we will make sure we do the right thing and help them and assist them. But they can't necessarily come in, especially during this time. I just want to put that out there.
No, and I appreciate that. That was me being over eager. I want people to vote. Right. So, Mark, we can't we can't forget about what just occurred down in the state of Florida. Could you enlighten us a bit?
Well, it's a long-standing problem, and it's really been sort of ground zero in this whole movement and question about voting with a felony conviction. The big picture is, of the 6 million people we calculated were disenfranchised in 2016, more than a quarter of that whole national population were in Florida, about 1.8 million. And of those people disenfranchised in Florida, the vast majority, about 1.5 million, had completed all terms of their sentence and were still disenfranchised. And so in Florida, for example, you could have been an 18-year-old in 1980 convicted of a first-time larceny. You might have been sentenced to probation or community service or some mix, never spent a day in prison. You were disenfranchised for the rest of your life under policy in Florida, unless you got the governor and the pardon board to issue a pardon to restore your rights. So there's been legislative attempts, there's been litigation trying to change policy in Florida. And in recent years, a campaign led by formerly incarcerated activists succeeded in getting an issue on the Florida ballot in 2018 that would restore voting rights to almost all people once they completed their sentences. Florida has a high threshold for ballot issues. You need to get 60% approval of the voters. They got 65% of the voters approving this, and this included strong support among both Democrats and Republicans to restore these rights. Shortly after the ballot campaign was successful and people were starting to register to vote, the legislature, and I have to say it was the Republican Party and the Republican governor who pushed this, passed legislation around what were the determinants of completing your sentence. So whereas most people may think once you're off parole or probation supervision, the legislation that passed said that if you have any outstanding fines and fees associated with your conviction, then you haven't actually completed your sentence. So this was challenged in the courts. One of the arguments made initially was that essentially this equated to a poll tax. If you were a millionaire who had done time in prison the day you got out and finished your parole supervision, you could register to vote. If you were an indigent defendant convicted and got off parole with a clean record, then you were not eligible to vote if you still had these outstanding fines and fees. Federal judge essentially acknowledged this and said this did equate to a poll tax, and furthermore, it had been demonstrated the state of Florida had virtually no ability to tell people if they owed fines and fees, and if they did, how much that was. There was no centralized database for that. That decision was appealed, and the Court of Appeals overturned it and essentially said, no, you have to pay your fines and fees before you can regain your right to vote. Expert witnesses called in the trial reported that they had estimates that roughly 750,000 people who had completed all other terms of their sentence still owned fines and fees, and it was also clearly documented that the county clerk's office rarely could tell people how much they owed, although we know that it's often several $1,000s, which is a rather enormous hurdle for the vast majority of people going through the justice system. So essentially, we have what I think is very much akin to a poll tax that has been adopted there, and it's bizarre to say the least that the state is now enforcing a policy and they can't even tell individuals if they owe fines and fees or how much they owe right now.
Definitely, it sounds like a poll tax, and it'll be interesting to see how that case moves its way, presumably right up here to the Supreme Court. For those DC bar members, the appellate decision, the federal appellate decision, is Kelvin Leon Jones, Rosemary McCoy et al. Versus the governor of Florida et al. And that opinion was issued on September 11th of 2020, in case any of you want to do some additional reading. And it does, thank you for that overview, Mark, and it does set up a very interesting argument that could eventually make its way here to the Supreme Court, so that the Supreme Court would be asked to define exactly what a criminal penalty is, and presumably when it actually ends. So let's stay tuned on further discussion and debate on that issue. As this discussion starts to wind to a conclusion, Mark and Michelle, any final thoughts you want to share with our viewing audience? And please take the opportunity that if you see a way that our DC Bar members can assist, please illuminate that. Who wants to go first?
Well, I can start off.
Okay.
One important item I think as well regarding felony disenfranchisement and how it's practiced all over the country is that would be very helpful to take an international perspective on this. Just as our criminal justice system, mass incarceration, our use of the death penalty in this country is extreme by the standards of other democratic nations, so are our felony disenfranchisement policies. If we were to look at Western Europe, for example, roughly half the nations there permit everyone to vote, including people in prison. Of those countries that do disenfranchise with a felony conviction, it's almost always solely limited to the period of incarceration, never to probation, parole, or post-sentence supervision. So we are very much extreme by world standards. There have been constitutional court decisions in Canada, South Africa, Israel, and the European Court of Human Rights, all of which have upheld the right of people in prison to vote. And essentially, the argument, the conclusion they've drawn is that when you're convicted of a felony, you're subject to punishment for that felony, but that punishment should not involve taking away your fundamental rights of citizenship. You can be sitting in a maximum security prison, having been convicted of a very serious crime, and yet you still have the right to get married or divorced. You can buy or sell property. You maintain basically your First Amendment rights. The only restrictions typically are those that might violate the security of the prison, but other than that, you are still a citizen of the country who happens to be in prison and serving a term of punishment there. So, as we move along on consideration of these issues, I think we just want to keep some perspective on that and want to encourage other jurisdictions to what the DC Council has done, and to extend the franchise to a group that's long been forgotten in most states.
And I'm going to interrupt with the CLE code for today's session. The CLE code is M as in Mary, W as in Washington, 42. And I'm going to repeat that 2 more times for anyone on the phone. That is M as in Mary, W as in Washington, 42, and one final time, MW42. Thank you.
Michelle, any final thoughts from you?
I think Mark summed it up really well in terms of us looking at what's done internationally. But I think I also would encourage the attorneys, because the majority of attorneys who are barred in the District of Columbia are also barred in other states. And so they really need to look at what's going on in their states, in the states in which they're barred, and what are the rules and the restrictions, and educate your clients about their rights. If you have a client who is in the District of Columbia Department of Corrections, or who has gone to a Federal Bureau of Prison, is in another facility, educate them about their rights and their ability to vote. That is something we frequently, when you are in court and you do sentencing, attorneys will advise their clients of their rights. Start advising your client that they maintain the right to vote. If that's the case, and then the state and the location where they're located, we have to continually encourage people to vote. I am an avid voter. I voted every election since I was 18, because I had parents who pushed for voting and our right to vote, and continually pushed. It's almost like did you vote yet? And so we have to continue to say, did you vote yet? And and push people and make it so that this is something, and whoever you vote for, did you vote yet, needs to be the question that we continually ask. So every attorney, I would say, ask your clients, ask your peers, ask the people around you, did you vote yet? And do you plan to vote? And encourage them, not so much in a skeptical, like in their business, but encouraging everybody to do their part, because we have this right. And as we've talked about, it's easy to lose it. And so we, and it's harder to get it back. It's easy to lose a right, but it's hard to get it back. And so giving it back, restoring that vote, do you use it? And we need to encourage everyone to use their right that they have and encourage our citizens, all citizens, to vote and get involved on whatever level, whatever location you're at, and encourage the people around you and those who have this opportunity to vote.
Thank you, Mark and Michelle, for this most informative and energized discussion, and I hope that everyone listening has enjoyed it. Perhaps the simplest way to sum up today's discussion is this. Historically, voting restrictions have been used as a tool to keep minorities of any hue disenfranchised without a vote, without a voice. The fundamental right to vote should never be taken away just because you have a criminal conviction. The District of Columbia now stands on the precipice of history in restoring the voting rights of its incarcerated felons. Bravo to the District of Columbia for taking that lead, and everyone, please vote. Thank you.
On behalf of the DC Bar and the 2020 Conference Planning Committee, I'd like to thank our speakers for taking the time out of their busy schedules to present on these important topics. As a reminder, please be on the lookout for the email from the CLE staff to submit your codes for credit, as well as to complete the class evaluation. Feel free to send us an email at cle@dcbar.org if you need any help. We look forward to seeing you at future programs, and thank you. Hi, I'm Dennis Cuevas, Director of the CLE program at the DC Bar. We hope you're enjoying this virtual conference marking the 100th anniversary of the 19th Amendment. This session, Gender Equity in Education, the new Title IX regulations and beyond, is eligible for CLE credit in all states that have continuing legal education requirements. An alphanumeric code will be read out loud and displayed sometime during the presentation. Please take time to write down the code. Within the next 24 hours, those of you who have registered and paid for CLE credit will receive an email with a link where you will then identify the correct codes to receive CLE credit. As we enter our busy season with many CLE deadlines fast approaching, please allow up to 30 days to process your certificate of completion. Also, in that same email, there will be an electronic evaluation form. Please take the time to complete the evaluation. We need a number of them back for accreditation purposes, but more importantly, we review them carefully as we always look for ways to improve our classes. If you have any questions about obtaining CLE credit, feel free to send an email to cle@dcbar.org and we'll be happy to assist you. If you're watching this pre-recorded program during the live broadcast, please feel free to pose any questions that you have in the chat room, since our presenters will be available to answer any questions at that time. Now, without further delay, let me turn it over to our distinguished speakers. Enjoy the program.
Hi, everyone, and thank you so much to Dennis for those announcements. I'm really excited to introduce a great panel today with some wonderful panelists and a really interesting discussion. The topic today is Gender Equity in Education, the new Title IX regulations and beyond. And we have wonderful panelists, and we will have a spirited back and forth, I have no doubt. Let me just start off by introducing myself. My name is Sharon McGowan. I use she, her pronouns. I am the Chief Strategy Officer and Legal Director of Lambda Legal. I am based in our Washington, D.C. office. I lead the largest legal department for the nation's oldest and largest LGBT legal organization dedicated to securing full, lived, and formal equality for LGBT people and everyone living with HIV. And prior to joining Lambda Legal in February of 2017, I was an attorney in the Civil Rights Division of the Department of Justice and worked closely with colleagues in the Department of Education on issues including sexual assault and equal opportunity for LGBT students. I clerked for the First Circuit Court of Appeals for Judge Norman Stahl, and then in the District Court in New Orleans for Judge Berrigan, and graduated from Harvard Law School and the University of Virginia for my undergrad. Our second panelist is Nina Chaudhry, who is the General Counsel and Senior Advisor for Education at the National Women's Law Center, where she provides in-house legal advice to the center and works to protect the rights of women and girls to be free from sex discrimination in school. Ms. Chaudhry has served as counsel on several key Title IX cases before the Supreme Court and the Court of Appeals, representing girls who have experienced harassment and girls who have been discriminated against in athletics. Prior to joining the center, Ms. Chaudhry clerked for the Ninth Circuit for Judge Michael Daley Hawkins. She received her JD from Yale Law School and her undergraduate degree from the University of Maryland at College Park. And then our third panelist is Justin Dillon, who is a former federal prosecutor and a partner at Kaiser Dillon PLLC in Washington, D.C. He has gained nationwide attention for his work representing students and professors in campus misconduct cases, and he and his firm have handled issues for more than 100 schools. He has also spoken on these issues before organizations such as the American Bar Association, the National Association of Criminal Defense Lawyers, the DC Bar, the Virginia State Bar, Harvard Law School, and the University of Kentucky's Center for Research on Violence Against Women. He graduated from Duke University and Harvard Law School. So as you can tell, just even from these bios, we will have a diversity of perspectives on these issues. Just to give you a preview of how we will be using this hour, the first portion of our discussion will really be a back and forth between Nina and Justin talking about the Title IX regulations, sort of the situation that we found ourselves in at the end of the Obama administration and the changes that have been affected in this administration and what the responses have been to those. And then at the end of the conversation, I will weigh in with the perspective on how some of the developments around LGBT students in particular interfaces with the larger Title IX conversation about preserving gender equality, including equality for LGBT students throughout our educational system. So with that, let me start off by asking Nina if you can set the stage a little bit. Addressing the issue of sexual assault in schools was a high priority for the Obama administration. So can you tell us sort of where we were at the end of the Obama administration to set this up as a background for our conversation?
Sure, and thank you, Sharon and Justin. I'm excited to be part of this panel. Thank you to the DC Bar. So I think it's important to go just a little bit farther back to 2001 when the Department of Education issued guidance after notice and comment. And there had been a few Supreme Court cases in the late 90s dealing with Title IX and sexual harassment in schools. So the 2001 guidance provided that once a school has a notice of possible sexual harassment of students, whether it's carried out by employees or other students or third parties, it has to investigate promptly and take steps reasonably calculated to end harassment, to eliminate any hostile environment, and prevent the harassment from occurring again. That guidance also said that both employees and students of public schools are entitled to certain constitutional due process protections, and that those rights established under Title IX have to be interpreted consistent with due process. But unfortunately, sexual harassment, which includes sexual violence, remained and still remains a pervasive problem on campuses and in elementary and secondary schools across the country. And so, fueled by student activism and schools asking the department for help in understanding their Title IX obligations, particularly regarding sexual violence, in 2011, the Obama administration Department of Education issued a Dear Colleague letter on sexual violence. And then in 2014, it issued a set of questions and answers. The 2011 letter provided clarity on how schools should address peer sexual harassment, as well as steps that schools could take to respond in accordance with the Title IX regs and that 2001 guidance that I mentioned. It reiterated the importance of schools offering services to survivors like tutoring or mental health care to ensure that they can continue to learn in the wake of sexual harassment. It also discussed what constitutes a prompt and equitable adjudication or hearing process or investigation process, I should say. And it also made clear that Title IX requires schools to provide both complainants and respondents equal rights and opportunities throughout any investigation and appellate process. It did, the 2011 letter, discourage schools from allowing a complainant and alleged perpetrator to directly cross-examine each other because doing so can be traumatic or intimidating for the victim and thereby could possibly escalate or perpetuate a hostile environment. And it also reiterated that schools should use the preponderance of the evidence burden of proof when investigating complaints of sexual harassment, as the Department of Education has been doing for decades, as courts do in civil rights cases, and because it's the fairest standard that doesn't favor one party over the other. And then finally, the 2014 Q&A document essentially just responded to more questions from schools and provided examples of proactive efforts that they could take to prevent sexual harassment and violence, and also remedies that they could use to address harassment and violence.
Great, thank you, Nina. And so let me turn it over to Justin, because obviously while many people welcomed this action by the Department of Education, there were some who had concerns about what the Department of Education had done, and in many ways, what we are seeing now from the DeVos administration and the Department of Education, including these regulations, is a reaction and a response to some of those concerns. So can you lay out what the concerns were with how the Obama administration had approached it and how you see the regulations as responding to those concerns?
Absolutely. And I also want to echo what Nina said. I'm grateful to be a part of this panel with my esteemed panelists and also for the DC Bar letting us talk about these things. So there's a couple of problems, I think, with what the administration did, even though I think it was well-meaning when it did it. Number one, it was illegal. The Dear Colleague letter in 2011 mandated that schools use the preponderance of the evidence standard. Nina used the word reiterated. But it had never said that before. It said it for the first time as a mandate. Schools like Cornell, Princeton, Columbia, and UVA were using the clear and convincing evidence standard before the Obama administration told them they couldn't. Now, the government has the right to tell you what to do, but it's got to tell you what to do by going through the right process. And here, in that case, it didn't. It used just the Dear Colleague letter as opposed to going through formal notice and comment rulemaking, which it was required to do. And actually, our firm ended up suing the administration because of that. And then in that case got sort of mooted out when the Dear Colleague letter was withdrawn after Trump took power. So procedurally, I think Nina and I will probably differ about the legal basis for what the problem was. Whether there was a problem, I think there probably was. I mean, I think it was a good thing that we're paying more attention to these issues now, but I just think you need to do it in the right way. And I think some of the issues that have prompted the new regulations were the pendulum swinging too far. I can give a few examples. Notice and getting a copy of the evidence and talking to witnesses. So under the pre-regulation world, a school didn't have to tell you what you were charged with. I literally had a school in the DC area once send my client a letter that said, "You're accused of sexually assaulting 3 women in the fall of 2017. Please respond by next week." When I called the general counsel to say, what is this? We need more notice. She said, "He knows what he did." And I don't think anybody who cares about a fair process, much less due process, would think that that's fair. The new regs have solved that problem and make you give more notice. Similarly with gathering evidence, some schools literally bar you from talking to any witnesses, and that has a uniquely burdensome impact on respondents. Complainants, what happens often is something happens, they talk to a lot of their friends about it, sometimes for a while. I've had several cases where the complaint wasn't filed for 3 years, and then the respondent gets it and wants to go talk to witnesses, but can't do that because the school bars them from doing that. The regs also fixed that problem. And a final one is getting a copy of the evidence. I've had several cases, one in particular I remember, where the investigation file was several hundred pages long. I think it was literally about almost a foot high, probably closer to 1,000 pages, because the two parties had dated for a long time before the complainant brought the complaint, and there were hundreds and hundreds of pages of text messages. They wouldn't give us a copy. We had to go into the DC campus of that school and sit in a conference room for 2 straight days with no computers and just taking notes. And the regs won't allow that either. Now you get a copy of the evidence. And so I think it fixed those things. And it did other things like cross-examination. But I think there are things that are even uncontroversial problems with the current process that it fixed. And that I think it was about time they did.
All right. So, we could probably have much of this conversation be like, and Nina, but let me give you just a little bit of sort of formulation here. Certainly from Lamb Legal's perspective, we know that there were a number of significant things that were done by the Department of Education through guidance documents, including Dear Colleague letters. And there were often ways in which sort of there was an objection made to the use of that vehicle that we actually thought were legitimate ways to clarify the meaning of existing law in conjunction with the development of the case law, consistent with the role of the Department of Education. But Nina, let me ask you first, maybe if you want to sort of just offer some additional thoughts, if you have, about sort of the propriety of the prior way in which the department had done it, just from the procedural standpoint, and then I'll let you pick, a couple of things maybe to respond to in terms of your reactions to Justin's critique of what they had done and how the response is set forth.
Sure. Procedurally, I will just say that in our view, it wasn't, creating any new rules. And so, as you said, Sharon, lots of agencies issue guidance. And so, that we don't obviously agree that procedurally it was a problem. But I want to say, in response to what Justin was talking about, that, clearly those examples that you provided are problematic. And that under the 2011 guidance and even the 2001, what we would say is that schools were not getting it right, for sure, in many situations, but that wasn't because of the rules. In fact, the rules, as I explained earlier, talk about making sure that there's a fair process for both complainants and respondents. And of course, due process requires notice and an opportunity to be heard, in public institutions, and fundamental fairness, would require the same in any process. So our view is that in those situations, schools were not doing the right thing, but that was not something that the rules required or in any way, made them do. And that, in fact, now what has happened is that DeVos has issued rules that has swung the pendulum so far in favor of respondents that it's really going to have a chilling effect and hurt survivors. And we can talk a bit more about that.
Yeah, Nina, maybe can I ask you just to go in a little bit deeper? Particularly, you had identified the concerns about sort of the cross-examination and sort of the ways in which there are concerns about how the mandated process now really does potentially result in a re-victimization of people who have experienced sexual assault and abuse, and the chilling that might result in terms of their willingness to move forward. So can you just talk a little bit more about that? And then Justin, I'll let you offer then your perspective.
Sure. So, one of our concerns, and we have many, and full disclosure, we have sued the Department of Education over the final rule that was just issued in August of 2020. But one of them involves this requirement for cross-examination in investigations. So previously, schools were strongly encouraged to have students submit their investigation or hearing questions to a trained third party who would ask the questions on their behalf. And schools had various models for doing this. But under the new rule issued by Secretary DeVos in higher education, survivors and witnesses in sexual harassment investigations will be forced to submit to cross-examination directly, orally, and in real time by the respondent's advisor of choice if they want any of their statements to be considered as evidence by the school. So the respondent's advisor, first of all, could be an angry parent. It could be a fraternity brother of the respondent. It could be a faculty member who oversees the survivor's academic work. It could be a criminal defense lawyer, even if the survivor has no attorney or can't afford one. And to make matters worse, the rule not only requires this live direct cross, but it also prohibits schools from providing the evidentiary rules and protections that make cross-examination work in courtroom proceedings. For example, if a survivor refuses or is unable to answer even a single cross-examination question, perhaps because it's too traumatizing, then the school will be required to disregard all of the survivor's statements in the formal complaint, at the live hearing, in all other written or oral evidence, even if, for instance, there's a statement in a video of the incident that clearly indicates the survivor said no, or that the respondent admitted to sexual harassment in a guilty plea before a judge, and that respondent then doesn't testify and isn't cross-examined in a live hearing, then none of that is admissible. So there are these broad and sweeping hearsay exclusions that are extremely problematic.
So, Justin, let me sort of turn back to you. In the face of this critique, I mean, one of the things that I've heard, and I'm doing my best here to be a sort of a neutral moderator and sort of pulling out these arguments, again, with full disclosure that sort of sexual assault and harassment is a particular problem for LGBT and gender nonconforming students. So we obviously sort of have a dog in this fight. But particularly, Justin, one of the critiques of the rule is that it is transforming these proceedings into criminal proceedings, when in fact the bar should be set at a very different place with respect to schools' obligations to addressing these things that have these kinds of actions that have such a deleterious effect on educational opportunity. So let me sort of kick it back to you sort of with a reaction to that point, but then also to the extent there are other things in response to Nina that you'd like to add.
Yeah, no, I appreciate it, Sharon. I think I hear that concern. I think the stakes are really high. And so I think people who are charged with these things need to have some level of pretty serious due process. I think if schools are going to put a suspension or expulsion on the line, then you should have the right to, I think, challenge the evidence against you, whether it's through cross-examination or other things. If they weren't going that way, I think I wouldn't oppose some sort of sliding scale, which is, okay, if we were to say take suspension or expulsion off the table, you're entitled to less due process. But if that's on the table, I think you should be entitled to process. And if it's quasi-criminal, well, that's because, frankly, the effect on your life is sort of quasi-criminal in terms of how it can follow you around. And I want to respond to a couple of things that Nina said. One, I think we may interpret the regulations differently. And, of course, no court has interpreted them yet. I don't actually agree with her interpretation that if a complainant who is not, of course, yet deemed to have been a survivor because they're just bringing a complaint, if a complainant fails to answer one question, I don't see anything in the regulation that says you throw out all of the testimony. I do believe if they don't show up for the hearing or if they refuse to be questioned at all, then everything they've said can go out, would be inadmissible. And I think that could create problems. And I think Nina and I agree here. I mean, I think that the one example that I thought of when I saw the regs was quid pro quo sexual harassment. Teacher goes to student, says, student, sleep with me or I'm going to give you an F. She sleeps with him, and then she later brings a complaint. And she doesn't show up at the hearing. You couldn't get into evidence the quid pro quo statement by the professor. And that's absurd, right? So I think that is probably an unforeseen consequence of this rule. I think it is probably not that likely to happen in practice. But so I think Nina and I probably would agree that there could be certain problems. But I don't think failing to answer one question excludes everything. And in terms of, Nina mentioned that the schools could have, third parties sort of ask the questions, train third parties. That'd be great, but that's not what happened. And I mean, I've seen so many hearings. They would pick and choose what questions to ask. They would reword the questions. They would, if anybody who's done cross-examination knows, even if you're not in cross, sometimes you want to ask questions in a particular order for a reason. And they wouldn't do that. They'd mush it all into one big question. And so I think in practice, these trained third parties tended to, frankly, go real easy on the complainants and real tough on the respondents. And then finally, with respect to the chilling effect, I'll be honest, and I've said this before, it will chill some complaints, but I think it'll chill the ones that should be chilled. I think it'll chill the weak complaints that never should have been brought in the first place. But I don't think it will chill the genuine ones that really should be brought. And I think that's as it should be. I think that right now, the processes have been, in recent years, the processes have been set up to really favor a complainant being able to sort of toss off a complaint. It makes it without a lot of effort, without a lot of screening, and you can kind of turn the respondent's life upside down. I think to have a system that makes the complainant think twice about that is a good thing. And I suspect that is not something that Nina and I will agree on.
So Nina, let me ask you, both in terms of sort of responding to Justin, because I do want to get to a chance for you to talk about the lawsuits that have been filed, but specifically to the extent that the National Women's Law Center lawsuit is moving forward. But just, in terms of sort of other things, that I think have been identified as problematic with the regs. There's also this question about sort of limiting, what it means for somebody to sort of be within the scope of the protections, the notion that the complainant must have been attempting to participate in a particular educational program, a real narrowing of an understanding of sort of where there should be a recognition of how conduct is affecting educational opportunity, and also issues about sort of who the complainant must bring that information to. So I was wondering if you maybe could flesh that out, and then to the extent then if that naturally sort of leads you to talk about sort of what the state of play is with respect to the litigation, I'm happy to have you do that.
Sure. So before I state a few more concerns that we have, just to respond, I think that what the department has done here, and the reason we've argued that it's arbitrary and capricious under the Administrative Procedure Act and our lawsuit, is that they imported some of the things from, the criminal context or courtroom proceedings, but they picked and chose what they were going to do. And so they said, oh, you have to have a live hearing. But then we have these sweeping, hearsay exclusions that you don't even have in criminal cases or civil cases. And, they don't have all the evidentiary rules or anything. And so, again, I don't think that it's solving for the problem that they intended to solve for. And if training was the problem, and, we have, declarations from people who have studied this for years and said that, there are models with, it doesn't have to be a single investigator, but other models other than a live hearing are far less traumatizing. And even like the Association of Title IX Administrators said that this live hearing requirement will reduce complaints by 50%. So I think that, we will obviously disagree, but I think if they were going to do it in this way, they didn't do it. They did it in sort of a haphazard way. And that's our complaint, among others. But a few other things just to flag. Yeah, Sharon, as you were saying, so one of the big problems with the new rule is that it allows schools to ignore students' complaints if they were harassed in the wrong place or if they told the wrong person. So before, previous policy said that schools had to investigate all student complaints of harassment, regardless of where the harassment occurred, because you have to determine if it affected the student's ability to participate in education and classes and school activities. But under the new rule, schools are actually required to dismiss complaints that occur outside of campus-controlled buildings or educational activities. And what that means is that in practice, this is going to be devastating for students who are sexually assaulted at a fraternity that may not be officially recognized by their university, in off-campus housing where 9 out of 10 students live, or for students who are harassed or stalked online, and then they're forced to continue attending class with, the alleged assailant, or maybe even be in a class taught by their alleged assailant. Also, the new rule says that schools can ignore students' complaints if they ask the wrong person for help. So again, before schools had to address harassment if a responsible employee designated by the school, there are different categories, knew or should have known about it. And they also had to address all employee on student harassment that occurred in the context of the employee's job duties. But now schools can ignore incidents of harassment unless the Title IX coordinator or a small subset of high-ranking school employees who have the authority to institute corrective measures have actual knowledge of the incident. So that means that as survivors from Michigan State University and the University of Southern California and Ohio State pointed out, that had this proposed rule previously been in place, their schools would have had no responsibility to stop serial predators like Larry Nassar, like George Tyndall, or Richard Strauss, just because those victims reported the abuse to coaches and trainers instead of to the right employees, even though those doctors sexually abused countless students in the context of their jobs. So there are a number of concerns we have. They're outlined in our materials, but those are two big ones.
Right. And so, Nina, before we talk about the litigation, Justin, let me just give you a chance, to the extent that there are things specifically about those concerns that you'd like to sort of offer a different perspective on. Let's do that, and then we'll talk about the litigation.
Sure. At the risk of making Nina fall out of her chair, I'm going to agree with her on some of what she just said. So I actually, and look, I represent students. I don't represent schools. I sue schools. So I don't really care what schools are or are not sort of forced to do, right, except be fair to my clients. I agree with Nina. That a standard that says, you have to have a high-ranking administrator with actual knowledge, that seems a little bit much. I think that as long as, I don't know if I could define, because it's sort of not the area of law that I really practice, sort of what level of knowledge should be required. But I don't think there's a problem with requiring, with having the rule be, look, if the school sort of writ large becomes aware, it should take some sort of action. Now, what their liability should be, if, let's say, I can see how the department might draw a distinction between I told my RA who's a senior and I told the Title IX coordinator, right? There might be some interesting distinctions to be drawn, but I agree with Nina that I think, this is, you don't want to create so narrow a sort of a reporting or sort of action obligation that the school doesn't take action when there are serial predators. And I think there are some. I think they're overstated, but I certainly all the ones that Nina named, yep, they all check those boxes. So I agree with that. I just think that when they do that, whatever triggers it is sort of, I come in the scene next, right? Like, just be fair, right? However you're going to handle the cases, just be fair when you handle them. But anyway, I just wanted to say I agree with Nina that, about that. The one place I think, just to sort of, keep it interesting, that we would disagree is, I think, look, if you have two kids who are at the same college who are not on a school-sanctioned study abroad program and both, get drunk in Paris and, somebody later says that they were too drunk to consent, I don't think that's the school's business. They're not on the school program, and the fact that they happen to both be college students, I wouldn't say that is something the school should concern itself with the Title IX process. Again, I suspect Nina will disagree, but frankly, those cases are a much smaller universe than the cases that Nina's describing.
Great. And Justin, let me just take that as an opportunity to clarify. I think I may have misspoken reading your bio. I think I may have suggested that you have represented 100 schools, but what I think your bio says here is that you have represented students and professors in cases involving 100 or more schools. So No, I just want to sort of make sure that I wasn't sort of misrepresenting sort of who you have been representing in this work. So,
Not school lawyer.
all right. And you also are not representing the Department of Education, but I may very well give you a chance to sort of offer your 2 cents after what Nina has to say about the lawsuit that the Women's Law Center and others have filed. So, Nina, the regulations were published in final form in mid-August, and shortly thereafter, there was litigation that we all probably could have predicted. So, tell us about the cases and particularly the state of play with respect to your lawsuit.
Sure. Well, there have been 4 lawsuits in total so far that have been filed against the department, and they make a variety of arguments. I'll list just a few. One is that the new regulations are themselves discriminatory because they create sort of a separate standard for sex discrimination than the department standards for other types of discrimination based on race or national origin or disability. We've already talked about some of the problems with, reducing colleges and schools' responsibility to respond to reports of sexual harassment. The new rule also narrows the definition of sexual harassment to which schools must respond, and effectively it makes it, it requires harassment to be so bad that it really interferes with the student's access to education before the school has to do anything about it. We talked about the live hearing and cross-examination process, and the, hearsay exclusion. The other thing I wanted to say is that, we have a claim that the regulations are discriminatory in violation of the Equal Protection Clause because they reinforce harmful stereotypes that were actually reflected in statements made by current and former members of the department, which perpetuate rape myths and the belief that survivors of sexual assault are somehow less credible and are lying about their experiences. So, there are lawsuits that have been filed by the ACLU, by a variety of 17 states and DC. The attorneys general, they're sued in a multi-state action. And then there was another one by New York State and the New York City Department of Ed, and then our lawsuit. The 2 attorneys general suits, the preliminary injunctions in those cases were denied. So they're moving forward to summary judgment briefing. And in ours that we have brought with Morrison and Forrester and also Diane Rosenfeld, who's a director of the Gender Violence Program at Harvard Law School, we argued many of those same things. And we actually have a hearing coming up on October 14th. The judge did not want to deal with a preliminary injunction, so he said, let's move right to trial, or what I see as sort of more of a permanent injunction hearing. But so we will see how that goes. And in our lawsuit, I should just say we're representing advocacy groups, 4 different advocacy groups across the country who provide services to survivor, as well as a 10-year-old elementary school student from Michigan whose school didn't respond to her complaint of harassment, and then 2 college students whose schools have begun investigating their complaints of harassment.
Great. And Justin, can you sort of offer some perspective on, the reservations that the judges have had to date in terms, at least in the preliminary injunction context, and sort of your assessment of how this is going to continue to play out?
Sure. And I'm happy to respond to some of the criticisms. I think judges have, so far at least, have thought the education department did it right. I mean, they took forever, as anybody who does things on my side of the table will tell you. And they fielded a ton of comments and they responded to them. And I think, frankly, they were very, very thorough. And I think the administrative record bears that out. So I don't think that the lawsuits will be successful. And obviously, of course, I hope they will. I think this is a new day for due process. With respect to 3 of the arguments that Nina was making, I'll just touch on those briefly. I'll put my Department of Justice lawyer hat on. With the idea that it's discrimination because there's a separate standard for sex discrimination. I mean, what was the Dear Colleague letter, right? The Dear Colleague letter sort of wanted that and said, in Title IX cases, you have to use preponderance and we discourage cross-examination. So there's sort of a goose gander problem a little bit. Everybody seemed to be just fine with a separate track as long as it was complainant focused. But now that it's a little more sort of equal or respondent favoring, it's discrimination. And I don't think that argument would be successful. With respect to narrowing the definition of sexual harassment so that it has to interfere with education to be actionable, that's the statute. I mean, Title IX isn't just some sort of freewheeling law that says anything you think might be gender biased, the government can stamp out. It's got to interfere with your access to education. So, for example, in the pre-regulation era, pre-new regs era, if somebody if a male student catcalled a female student on campus, that could be prosecuted under the Title IX policy. That may be a stupid and rude and awful thing to say, but the idea that let's say you do the whistle thing, at somebody is going to interfere with education is, I think, ridiculous. And wouldn't interfere with education, so it shouldn't be a Title IX problem. And then with the third argument, that the regs reinforce sex stereotyping and says that the accusers are less credible. I don't think that's true. I don't think someone who says they've been sexually assaulted is any less credible or any more credible than anybody else who says a thing has been done to them by another person. And generally in America, if you say somebody did something to me, that person has the right to question you about that and put you through your paces. So I don't think we don't start by believing, which is a very fashionable phrase, in any context of the law at all. We should start by listening, start by being sensitive, and start by doing a whole bunch of other things. But we shouldn't start by believing. And I don't think that creating a system that is fundamentally requires one's evidence to be tested is biased against complainants necessarily. So I guess those would be my sort of, if I had my DOJ hat on, those would be my responses.
Thank you, Justin. You certainly, you wear it well. So let me offer Nina certainly a chance to respond, but in terms of some of the things that I know that I've heard in this context that has been troubling is, well, Justin, I hear your argument about, something that is, like a whistling, and I think we could have sort of differences of opinion about how much that interferes with somebody's ability to have a meaningful educational opportunity. But there's a conflation between what is the standard for holding the school liable for money damages versus when does the school have an obligation to step in and do something, right? Does it have to get to a point of actionable money damages inducing sort of liability before the school is able to respond? And so, Nina, to the extent that if you want to sort of react to that or any of the other things that Justin has said, but Justin, sorry, I don't think I mischaracterized what you said, but I'll let you clarify the question as I've posed it.
Yeah, let me jump in because I think Nina and I will agree here. I'm only talking about what you can go after the respondent for, not what the school, can be liable for money damages are. Again, I'm sort of agnostic about school liability. The more schools that are liable for stuff, the better as far as I'm concerned.
Okay. Nina, go ahead.
But I mean, I think, Sharon, I agree with you that what the department did here is they imported the standard for money damages from the Supreme Court cases that, we actually were involved in the late 90s into the school context in a way that it is tying the hands of schools. And I want to focus for a second on the K-12 context, which people often just forget about, that a lot of people don't even realize Title IX applies at the K-12 level, but it certainly does. And under this new rule, a teacher who sees something on the playground, a little boy or girl, inappropriately touching another little boy or girl, whatever happens, ideally what you want is for that teacher to be able to just say, hey, whatever, we don't do that, to intervene. And, this new rule sets up a lot of barriers to that. It, requires, things to happen over a period of time. And it would actually prohibit a teacher from doing just that, from sort of nipping things in the bud. And, it also could expose K-12 kids to hearings. It doesn't require that, but certainly if there's like a camp or something happening on a college campus, the way we read the rule, it would actually subject those kids to the same sort of potentially re-traumatizing hearings that colleges are forced to use. So I think there are a lot of problems with it. And, just to respond to Justin's point about different types of discrimination, I think our point would be that under the previous rules, the preponderance of evidence, for instance, was used in all cases, whether it's Title IX, Title VI, disability, so that it wasn't, we're not suggesting that there should be, special standards for sex discrimination. But here, in fact, they have all these different rules and they're explicitly just for sex discrimination in ways that are going to make it that much harder for victims of sex discrimination, who, by the way, are women and girls and boys and men, right? It's not just a female problem. It's going to make it much harder for them to come forward and get relief.
And so, Nina, let me ask you a question before we transition a little bit here. To the extent we have folks who are watching this program who are advising schools, what and want schools to continue to do as much as they think that they can, even in this new environment, what are the things that you would want as takeaways of notwithstanding these rules, you can still do X and you should because they are good things to do? Are there any sort of pieces of advice you might sort of offer about how to navigate this period where the legality of these regulations are still, in play?
Yeah, I mean, it's interesting. I've talked to some folks who are at schools. I have some friends who are working there, and the rules. We haven't talked about this, but they do allow schools to have sort of a separate process, or they say that anything that doesn't fall under Title IX sexual harassment, as it's narrowly defined by this rule, can be addressed by a separate parallel process. Which I think if I were a school, I would just be, really frustrated by, because, if you didn't have that process, now you have to create a separate process. But I think schools who want to continue to address all forms of harassment and not just this narrow set that the department has indicated, or want to be able to address harassment that may happen off campus but have a real impact on students, education on campus, because they're going to classes and living in dorms with people, can set up that separate process. And my understanding is that many who have the resources to do so have, but I think the problem is that for those who don't, and again, this affects everybody from K-12 all the way up through graduate school, not all schools are going to have the time and the resources to do that.
Great. So let me use this as an opportunity just to pick up on Nina's point about how this is obviously an issue that I think people traditionally think of as affecting the opportunity of women and girls. But, sex discrimination is something that we know that happens to both boys and girls, men and women. And in particular, the LGBT community has often sort of found ourselves suffering from sex discrimination due to our failure to conform to gender stereotypes. But of course, now with the result of the Supreme Court's decision from this past June in the Title VII context, we have some additional sort of wind in our sails in terms of being able to use Title IX as a sort of a tool to be able to sort of address these issues. So because even though I'd enjoy moderating myself for this portion of the discussion, I'm going to hand it over to Justin, who will sort of lead us through a conversation about how some of these developments with respect to LGBT students interacts with this other conversation that we're having.
Terrific. And Sharon, I hope I can be as gracious and even-handed a moderator as you are. I'll see if I can find something that you and Nina disagree about. Probably. So Sharon, Bostock decision. First, I guess, tell us about the Bostock decision, and if you could also explain, why that would apply in the Title IX context, since it was, of course, a Title VII decision. What do you think that could mean for education down the road?
Yeah, no, Justin, it really was the culmination of many years of litigation that started in the late 80s and early 90s, frankly, with the Price-Waterhouse decision, which was a Title VII decision that established that denying somebody equal employment opportunity based on their failure to conform to sex stereotypes could amount to a form of sex discrimination. And in the years following that, we actually saw a number of transgender employees able to bring successful Title VII claims based on the fact that they were experiencing discrimination due to their failure to conform to the employer's idea of who men are and who women are and can and should be. And over the time that followed since that sort of mid-2000s, we started to see courts also recognizing that the discrimination that LGB, lesbian, gay, and bisexual people were experiencing was also grounded in many of these same stereotypical views. But in both circumstances, courts also recognized that when you are discriminating against someone because they are either transitioning on the job, had previously been on the job as male, but now was coming as their authentic self as a woman, or they were being fired because the employer learned that when they were talking about their spouse, they were referring to in my case, a female spouse, and I didn't have the male spouse that the employer might have thought that I had, that the fact that a male employee talking about his female spouse would not have experienced discrimination was also a very clear way to understand that what was happening here was discrimination because of the employee's sex. And so we had three different cases presenting two different issues presented to the Supreme Court, two involving the question of sexual orientation within Title VII, and one involving gender identity under Title VII. And in a 6-3 decision written by Justice Gorsuch and joined by Chief Justice Roberts, there was a very straightforward sort of textual analysis in many ways that built on language from Justice Scalia's decision in the late 90s in the On-Call case involving same-sex sexual harassment. And in that case, Justice Scalia said, I'm not going to tie myself up in knots over what forms of discrimination Congress may or may not have had in mind when it enacted the sex discrimination prohibition in Title VII. If it's covered by the words of the statute, then it's covered. And Justice Gorsuch, in a very sort of straightforward opinion, said, there's no way to disentangle the sex of the employees from the discrimination that they're experiencing based on their sexual orientation or gender identity. And so, in many ways, people look at this decision as being a watershed moment for employment. But what we do know is that Title VII, in many ways, I've described it as the North Star for our interpretation of other federal civil rights statutes, including Title IX. And so to the extent that the analysis that was used in Bostock isn't sort of related to anything specific about Title VII, it literally is, what does it mean to discriminate against someone because of sex? That is a phraseology that either it's based on sex or because of sex that you see in Title IX, you see in the Fair Housing Act and the Equal Credit Opportunity Act. So there is really no reason in our view why that analysis should not just sort of naturally extend to the other federal civil rights laws and frankly state civil rights laws as well that address sex discrimination.
So I would imagine, given this was a 6-3 Supreme Court decision with both the Chief and Gorsuch in the majority, the decision and its logic were immediately embraced by the Trump administration, which issued an order executive branch wide that we're going to follow this in every context. That's right, isn't it, Sharon?
Oh, would that have been the case? So, the particularly interesting thing here is that the Friday before the Supreme Court announced its decision in Bostock, the Department of Health and Human Services did a preview of a regulation that had been in the works, kind of like these sexual assault regulations, for many, many months, in which the department announced that they were going to roll back the regulations interpreting the sex discrimination protections of the Affordable Care Act, which are particularly interesting in this context because they are drawn from Title IX. We know Title IX obviously plays out primarily in the education context, but also sort of has applications in other areas as well, including the healthcare protections in the Affordable Care Act. And the regulations, the preview of the final regulations that were announced on June 12th completely doubled down on the argument that the Justice Department had presented in the Supreme Court, insisting that it was a very, very narrow definition of what constituted discrimination because of sex, that it was based on some kind of biological distinction between who men and women were, and anything, relating to gender identity or transgender status was not covered. And of course, we know the following Monday, that analysis was completely repudiated. And so we immediately called on HHS to pull back that regulation. It hadn't been finally published in the Federal Register to obviously re-examine what their approach had been. Not surprising to us, they did not do that and went ahead and the regulations were published in final form that following Friday. And then the following Monday, Lambda Legal was in court suing for, among other things, violations of the Administrative Procedures Act, saying it was completely contrary to law for them to go out with a regulation with an interpretation of what sex discrimination means that not only was, in violation of what the law had been prior to Bostock, but then didn't even sort of take Bostock into account whatsoever. And so we went in and we sought a preliminary injunction, not only with respect to that provision, but also with other protections that were rolled back, including provisions related to language access, and secured a preliminary injunction on September 2nd. So fortunately, those aspects of the regulation have been put on hold. And we think that obviously the Bostock interpretation as applied in the Title IX and Affordable Care Act context should continue to be operative and provide protection against discrimination on the basis of sexual orientation and gender identity as well. And I want to sort of give a hat tip to Nina, because obviously the National Women's Law Center also had one of the lawsuits that were filed within the days and weeks after the regulation, because obviously among the other things that the regulation did was roll back important protections with respect to access to reproductive health care, and imported, again, in a similar way, standards from another context with respect to sort of religious opt-outs that were not grounded in the statute and that we felt were beyond sort of what was allowed by law, and the court also accepted that in the context of our preliminary injunction hearing, striking down the importation of those kinds of provisions as well.
Okay. And before we bring Nina back in to get her take on this, let me ask you one more question. So you've outlined sort of the sort of short-term impact that Bostock has had in your success and in joining it in one context. let's go back to the education setting. Have you seen any results so far? And why do you think we're talking about Title IX here? Why do we care about Bostock? What effects do you see sort of down the road on a practical level, both for schools and for LGBT students moving forward?
Yeah, so Justin, we actually had a case that had been argued in the 11th Circuit regarding the access of a transgender student in Florida named Andrew Adams we had actually sort of litigated to trial, and the district court judge received an outstanding opinion from a Republican appointed judge, I might add. So this is not a partisan issue in our perspective. We put forth not only the evidence from the students and the teachers, but also from experts about Drew's identity and the importance of him being able to sort of live in a way that was consistent with his identity as part of his being able to access educational opportunity. And so that case had been argued in the previous December. And so we had supplemental briefing the 11th Circuit after Bostock. And a few weeks later, in early to mid-August, we received a decision from the 11th Circuit having no problem whatsoever in recognizing that the analysis from Bostock in the Title VII context should not only apply with respect to our Title IX claim, but to the extent that we also had an equal protection claim that was grounded in sex discrimination, understood that the exact same sort of rationale should apply there as well. There was a case that many people may be familiar with that has been pending in the Fourth Circuit on behalf of Gavin Grimm in Gloucester County, Virginia. His case has certainly received quite a bit of attention, and his bravery is noteworthy. And his case is also particularly noteworthy because it was his case where we saw the shift in position from the Department of Justice. It was one of the last briefs that I filed as an employee in the Department of Justice, was a brief by the Justice Department and the Department of Education on Gavin's behalf in the Fourth Circuit, which was a position that was then reversed by the Justice Department and then obviously was sort of tied to the withdrawal of the Dear Colleague letter with respect to the transgender guidance. So we already have two contexts in which we see courts recognizing the very clean applicability and transferability of the Bostock analysis in the context of the more traditional Title IX context that we think of when we're talking about these issues.
Let's bring Nina in to get her take on this. I think let's shift a little bit from the Sharon, what you've talked about to say the sports context, right? And as I think everybody knows, there's been litigation over allowing sort of biological males to compete in sport in sort of traditional female sports. And, people such as Martina Navratilova, right, have said that they oppose them. And I think that it should be biological males staying in their lane and biological females staying in their lane. Do you share that concern, Nina, as someone who's the National Women's Law Center? Where are you all on this position?
Yeah, I should, before I jump in there, just say really quickly that we also filed amicus briefs in the Adams and Grimm cases, and we're very glad to see the courts following Bostock there. I think, as Sharon said, discrimination based on sex is discrimination based on sex, and that should be applicable across all the civil rights laws. But yeah, to the sports context, Justin. So, I think our view is that policing who is or isn't female, and by the way, this is really only the laws and things that have been happening and the Connecticut situation where the Department of Ed has threatened to withhold federal funding, which it's never done ever in its life, because the Connecticut Association, Athletic Association, allows transgender athletes to play consistent with their gender identity. This is really only happening in the trans girls context, right? Or the trans female context. So our view is that policing that who isn't female is dangerous, right? It doesn't only erect barriers for transgender athletes, but also for cisgender women and girls who may fall outside stereotypical notions of femininity, right? What if you're a very tall woman or a very muscular woman or a woman who chooses to present in a more masculine way? Does that mean that you should be forced to undergo medical testing or be prevented from playing sports entirely, as Idaho tried to do? And in particular for Black and brown women and girls, we are very concerned that they would be more vulnerable to this sort of scrutiny, given racist and sexist stereotypes that already consider their bodies less feminine. And the other point I'll just make is that states across the country have already been allowing transgender students to compete consistent with their gender identity. I think there are about 19 states where the athletic associations already and for some time have allowed that. So this is not a new issue. It does seem to be a very controversial one that, folks have seized on recently to really try to drive a wedge. But it's not a new issue. And But I think what also we need to keep in mind in the bigger picture of women's sports is that, and we've worked on this for a long time, is that women and girls are still not getting sort of equal opportunities to play in general, right? They don't have all the teams they want at many, many schools. I still hear from parents and students regularly about that. They don't have equal fields and facilities, right? The girls softball field, that's such a common complaint, is often, just shoddy, no bleachers, no dugouts, no anything, and the boys will have like minor league baseball stadiums. There are some really big issues still left in sports, even 45 plus years after Title IX. And so there's still a lot of work to do.
And with that, I'm going to interrupt with the CLE code. Please grab a paper and a pen and write this code down. J as in justice, D as in David, 21. Again, I'm going to repeat that 2 more times for anyone who may be coming on through the phone. That is J as in justice, D as in David, 21. And one final time, JD, 21. Thank you.
All right. So as the resident JD on this call, let me turn it back to Sharon. I think we're hitting up towards the end of the time. Sharon, you want to respond to anything Nina said, or give us some sort of final thoughts about, as you look ahead and sort of see what all of this could mean for LGBT students moving forward? How do you see it? And do you have any concerns about where we're headed?
Yeah, no, look, I think that Nina's absolutely right that this is, again, a wedge issue. And in many ways, I see the shifting of narratives around the fear mongering around LGBT people and around trans people in particular sort of is a reflection of sort of ways in which prior arguments to exclude transgender people from public life no longer actually carry the resonance. That used to be that we had to be concerned about them being around children or some, like the fact that we're not even really having a legitimate conversation anymore about the need for transgender people to be able to access bathrooms. I mean, obviously there are going to always be pockets of people who are going to continue to try and push some of those kinds of transphobic narratives. But the fact that we are sort of now, shifting to this notion that somehow allowing the participation of transgender girls is somehow coming at the expense of women's educational opportunity, and particularly the opportunity of girls, to me is a sign of sort of the ways in which they have had to sort of try to refine their narrative to make it palatable. But the end effect is exactly the same, because what we're talking about here is a rule that imposes frankly, very arbitrary standards about who counts as a boy or a girl, and particularly in this context, we're talking about who counts as a girl, is not actually grounded in real science, because we know that there is a much more sort of complicated panoply of factors that result in sort of who you are in terms of not only your identity, but your bodies, things like that. And one of the things in the materials is a decision from the district court judge in Idaho, a Trump appointee, I might add, again, as part of this isn't always necessarily have to be a partisan thing. But when you actually go through the science, the real science, and not the made up science, this notion of biological sex is a made up term that is really just designed in many ways to erase the complexities of sex and gender and actually just continue to try and exclude transgender girls from sports. Because a rule that says that trans girls can participate in sports, but only as their birth sex, is basically saying trans girls have to stop being girls in order to have the ability to participate in programs and activities that we know are so essential to their self-esteem, to team building, to being part of a community, to having leadership, all of these things. And we know that schools have done this for decades. And when we're talking about sort of elite competitive sports, there are things that schools and athletic associations have done to try and make sure that there are, sort of policing sort of the outer boundaries of fairness based on, whether or not somebody is involved in, sort of medical care, that might sort of alter sort of their ability to compete in ways that are deemed sort of inappropriate for that kind of a controlled setting. But for the most part, what we're dealing with here is schools wanting to actually recognize in every way their students' identity and allow them to participate and grow in those spaces. So I think it's very easy to say, oh, well, trans girls shouldn't get to compete, as though it's like then they have some other way in which they get to do it. Just go to the other thing. But what that really means is actually sort of asking trans girls to stop being girls in schools, and nobody would ever sort of acknowledge that is a blanket ban on their participation. That is not just sort of some kind of, can't we just all get along approach here that I think is really important for people to understand in terms of what really is at stake here. And I'm just so pleased that we've seen schools like the schools in Connecticut who are standing up to the Department of Education. I mean, just recently we saw the Department of Education threatening to withhold magnet school money designed to facilitate the racial desegregation of Connecticut, holding that money over their heads as a way to force them to adopt a policy that would exclude transgender students. And fortunately, that current situation seems to have sort of resolved itself in the moment, but the notion that the Department of Education is using its limited resources and the Department of Justice is using its limited resources to go after opportunity for transgender students as opposed to expanding educational opportunity for LGBT students, particularly in the wake of a decision like Bostock, making clear that non-discrimination on the basis of someone's being LGBT is part of what is covered by our federal civil rights law, suggests that certainly at the federal level, they have truly lost their way. And hopefully, Lambda Legal and the National Women's Law Center will continue to sort of hold the line and fill that role for as long as is needed. But, I obviously am sort of certainly hopeful that we will no longer find ourselves in quite the adversarial posture that we've been in recent years with the federal government.
Great. Well, I think we're just about at time. So I want to thank our panelists, Nina, Sharon, and I guess me, since I'm playing moderator now, as Sharon played it before. I also want to make a plug for liberal democracy. Isn't this great, right? We all disagree. Some of us disagree with each other about certain things, but I think we had a very nice civil discussion. Nobody got canceled, I think, or silenced or anything like that. So, I wish if we could only import the sort of tenor and tone of the conversation we had here into the rest of the world as we move forward, I think the world would be a better place. So thank you very much to our panelists. Thank you to the DC Bar for all your hard work. And now, everybody, if you could please stay tuned as Dennis Cuevas, you'll see him once again, and he'll give you information about how to actually get CLE credit for watching what we hope was a presentation that you enjoyed and maybe learned a little bit from. So thank you so much.
On behalf of the DC Bar and the 2020 Conference Planning Committee, I'd like to thank our speakers for taking the time out of their busy schedules to present on these important topics. As a reminder, please be on the lookout for the email from the CLE staff to submit your codes for credit, as well as to complete the class evaluation. Feel free to send us an email at cle@dcbar.org if you need any help. We look forward to seeing you at future programs, and thank you.